next guest needs no introduction for listeners of our program because he is a certified friend of the show and a repeat guest. Welcome back to Consumer Choice Radio, criminal defense attorney Jerry Buting.
Thank you. It's good to be back on. Good to see you guys.
Great. So, I mean, it's we've obviously had some very, very high profile criminal cases with a lot of media scrutiny over the last, let's say, month or so, with the Rittenhouse trial, the Arbery trial, Ghislaine Maxwell, Jussie Smollett. It feels like a lot of eyes are on some of these big criminal cases. And so we figured who better to have on the program than yourself to chat about some of these things. And so I wanted to start just with a very broad question in regards to the Rittenhouse trial, what your perception is as someone who has defended folks, maybe not in a similar case to that, but certainly criminal proceedings in Wisconsin. What's your perspective on how that case proceeded, maybe how the media was involved, and things like that?
Yeah, that was an interesting case, and in part because people could actually see it live streamed, but there was video of the key points during the offenses that were charged, and no question that those videos helped the defendant. I think it was pretty clear that he, had a right to defend himself with people chasing him and whatnot. On the other hand, the people that were chasing him may have, thought he was a mass shooter. What do you do with somebody in that scenario? So there was an interesting interplay of those circumstances. Really, the case, I think, came down to the issue of provocation, because if you provoke an encounter with another individual, you lose the right to self-defense until you withdraw, and then, if you're being re-engaged, then you can get the right to self-defense reinstated. And so I think there was a lot of discussion in the trial about that the prosecution got that jury instruction on provocation. And a lot of viewers thought, well, just showing up to a protest with an AR-15, openly carrying, displaying, isn't that provocation? Probably not under the law. Some people maybe think it should be, but that act alone would not necessarily fall within the usual common law or statutory definition of what is adequate or inadequate provocation by someone charged with an offense. So I can understand the jury verdict in that case, given the evidence that was presented to them. They certainly had a good judge for the defense, unusually so, because he's not typically a judge that is considered defense-oriented. But there was definitely a lot of rulings and he's always been a quirky guy, but some of the rulings that were much more favorable for the defense in that case than in almost any other case I've ever seen. That certainly helped the defense as well.
Yeah, I think what made this case, apart from the facts of the case and everything, was, as you mentioned, that it was on camera, everybody was live streaming it, and we had an insight into what the prosecution's case was, what the defense cases was, and it's, for me, very interesting, because often I think you would agree that our criminal justice system and sort of the law and order types are all in on the prosecution. And in this case, people are breaking down the errors of the prosecution almost in real time. So what was that like for you, kind of seeing that? It's not necessarily about the facts of the case, but more how we're consuming it. It's not through a long burn Netflix documentary, wink, wink, but also this is instantaneous. It's live. You have people that are tweeting like crazy. I don't know what it'd be like for you if you have this in your next case where you have an entire, jury of peers behind you.
Well, actually, in the Avery case, that was being live streamed, and there were hundreds of people messaging us and tweeting, including some pretty well-known people. Chris Darden who was one of the prosecutors in the O.J. Simpson case and was at that time a law professor by then, he would actually email or tweet or, comment on what would happen that day. So we got some real-time feedback. You have to be careful as a defense lawyer in taking too much from that, because it's, there is a tendency to think, well, maybe this jury took what I said the wrong way. Certainly in the other case of the McMichael case, Ahmaud Arbery, there was a lot of criticism about some of the things that the defense attorneys were saying, particularly in the closing argument. And you worry about whether that has an effect on the jury. In my own case, in the Avery case, actually, the jury was not sequestered until deliberations. In the in the Rittenhouse case, they weren't sequestered at all, even during deliberations, which is a little unusual because the risk of being tainted by publicity might be greater under those circumstances. But I would go home on the weekends for maybe 24 hours during the Avery case. And one day we had a soccer party after indoor soccer with a bunch of parents there. And people had watched my cross-examination of the crime lab analyst. And I remember one parent who was like a lab tech herself thought I was too hard on her. And, so I started thinking, well, maybe the jury is going to feel the same way. And so I actually, I don't know if you call it pulled a punch, but in my closing argument, I actually said something about it and, apologized if anybody took offense, but made it clear that this is my job and they shouldn't hold it against my client. So, you do have to be concerned about it, but you have to be careful you don't take too much from what people might be tweeting or commenting about what you've done in a live stream trial.
On I don't know if this is the right terminology, but I'll call it jury integrity, because I know that came up in this case as the jury was selected for the Rittenhouse trial, where members of the jury were legitimately scared that their identities would be known, essentially by either opposing view, the Rittenhouse's guilty crowd on Twitter and the Rittenhouse's not guilty crowd on Twitter. How much does that play, the decision to sequester the jury or not? How much does that play, do you think, in regards to a fair trial?
Well, having jurors afraid of doing their job is not a good thing for our justice system. We need people to be honest and having personal integrity to be able to do what's right, not what they're afraid the consequences will be. And so during jury selection, this has always been an issue, even without a high-profile case. If there's enough of a coverage about it, during jury selection, defense lawyers and prosecutors have often asked prospective jurors that, hey, are you going to be concerned about, after you render your verdict, going back to your community and being criticized by your family or your friends or neighbors or whoever, co-workers it might be? It's much bigger scale when it's a high-profile case, particularly one that's split down the middle with very passionate people on each side. So it used to be, really until maybe the last 40 years or so, we did not have anonymous jurors, anonymous juries. And then they began to creep into the system when there were like mafia prosecutions or gang prosecutions where there were some actual threats before trial, or if not threats of individual jurors because they hadn't been picked yet, but that there was threats of witnesses or intelligence, so to speak, that the mafia people involved or the people who was in a gang that may have supported the defendant were going to do something to threaten the integrity of the trial. And so they began to do juries where people were not identified. And initially it became a problem because they started doing that where even the defense attorneys didn't know, or the prosecutor, who these people were. They weren't even told their names. It was juror 1, 2, 3, whatever. And the courts said that that's improper, that you don't have a right to a public trial and a fair trial unless at least the attorneys know that information. Then they started doing numbers jury where information is shared privately with the attorneys and the judge who are prosecuting the case, litigating the case, but not the general public. And so now that is.
And when you say anonymous, in regards to the defense attorney not knowing who they were, would they still see the jury in front of them?
In those cases, that they would see the jury, but they would not know who they were. They were not.
Okay.
Their names. They were referred to by the judge as, with initials or something. They were not told their names. They were not given any background information about them, and that was ruled to be improper. What you now see more commonly when there's a risk to the jury integrity is that they are not to be referred to publicly during the jury selection, questioning, or anything by name. But if they fill out questionnaires ahead of time with background information, that's supposed to be shared with both the defense and prosecutors. It's still, there are some very specific rules and rulings of when a judge should or should not allow that. Certain factors have to be made, and some judges just think that if there's any publicity, that's enough to use that kind of jury's numbers jury or anonymous jury to the public. But that clashes with the public's right to know as well. Who are these people? Might they have some unfair connection to the judge or to the prosecutor or to the defendant? And the public has a right to know too. So there's an interesting tension there, and it's supposed to be limited. Now, in a very high profile case, particularly where there might be threats to the jury's safety, it's pretty common. And in the Rittenhouse case, there was an allegation even that television reporter or somebody working allegedly for one of the networks was pursuing them and trying to take pictures of them. And that would be completely impermissible, because it might impact the jury and their ability to be fair and impartial if they know that someone's already coming after them, almost like paparazzi or something.
Oh yeah, there's probably a ton of that is kept at bay, thankfully, by some of these measures. Jerry, I have a question about sort of the prosecution and when they lay charges. And one trend that a lot of people are picking up on is the DAs or whomever kind of does the initial charges. In many cases, when it's a very public trial or a very public incident, will seem to lay down the charges very, very heavy. And the example that I'm thinking of just right now is we have this school shooter situation in Michigan, and I believe his parents have been in charge with involuntary manslaughter, one of these cases. We saw the sort of rack of charges against Kyle Rittenhouse. I know that a lot of people who are on the defense side have been always very critical of prosecutors' offices and ADAs and the like for these. But is this something that is a general trend? Is this something that perhaps is tapering off? Or is it just something that people are just now learning about that has been happening for a long time?
I think it's the latter. People who work in the system know this has been going on for a very long time. Prosecutors overcharge frequently, and they're supposed to ethically not charge something unless they believe they can prove the case beyond a reasonable doubt. But you do see a lot of times where they just pile on, and the hope is sometimes that it's a negotiation strategy. That if they raise the ante for a defendant who chooses to exercise the right to a trial, you could end up getting a rocket ride to prison, or in many cases, mandatory prison. But if you take this deal, this is what happens. Prosecutors make these offers to reduce the charges. Now, that sometimes backfires because the public doesn't really understand that. And if a prosecutor, I've had a case where a prosecutor did that, really never intending that the case would go to a verdict or would require a guilty plea to that serious a charge, But by the time the case was getting closer to trial, the public pressure against any reduction, they would have looked like they were being soft on this particular defendant for them to have reduced it to what it really was and what it really should have been charged as all along. So sometimes it backfires against the prosecution when they do that. But this has been going on for a long, long time, and I think the public is just now waking up to it and seeing how prosecutors can use this.
And on the note of that pressure, how much do you think some of these DA positions or ADA positions being elected officials plays into that? Where, and this may be my own biases coming through, because as a Canadian, I view
That's a
that as
Canadian
very
bias
weird
all
and
the way.
strange
That's what it is.
phenomenon, because because it for at least from my perspective, it feels as though then you are laying charges based on your own electability, which feels to me like that would skew on public perception. But I'm not sure. Maybe that's not accurate. Maybe you have a different opinion on this.
No,
So do you
think
feel
you're
that
right.
plays a role?
I think it does play a role, but it's not just with prosecutors, with judges too. Not every state, only about half of the states now in America have local state court judges elected. Many of them are appointed. People complain that there's problems there too, because they could be patronage jobs. The governor just hands out to people who maybe don't have the merit. It's like you sometimes see with ambassadorships handed out to smaller countries that are more like a political payoff for supporters. But some of the states have countered that and said, well, look, we will have panels that will go through the merits of any applicant, and the governor can pick from that to a point. But certainly when you have elected positions, whether it is a judge or whether it is a prosecutor, it is very difficult for them to separate the political risk in their decisions from their ethical responsibilities. They're human. It is, I'll take the Brendan Dassey case, it's illustrated in Making a Murder. A lot of people were really troubled after Making a Murder about how could that confession be admissible? How could that even come in? He was coerced, he was this or that. Well, it was a close call in that case. For me, it was obviously coerced, but even legally, it was a kind of a call that if the case hadn't been so high profile, maybe a judge might have thrown it out and said that this was a coerced involuntary confession and can't be admitted. But in a high profile case, that judge was never going to rule that the confession was inadmissible. The state's entire case would have collapsed without it, really. And he would never have been reelected. He would never have had the support of the local police. And they probably would have drafted another person to run against him in his next election. Well, you see that same kind of concern with prosecutors. Some of them, it's not just, can they get reelected to their current position, but some of them have ambition and they tend to seek higher office, maybe a statewide attorney general, and they can take this high profile case that's been, sort of dumped in their lap and make something of it. It's not always a conscious level pressure, because I think most prosecutors do try and be fair. They do know that they have rules of ethics that bind them and they're supposed to seek justice, not convictions. But in the heat of battle and public pressure, sometimes that's just very difficult.
Yeah, and the public pressure, for one, I want to get on that real quick, David, because you mentioned the reporter that might have been tailing the bus of the jurors, and it became a thing. And at least for the Rittenhouse trial and the Arbery trial, the media is a spotlight and is there in the room. You have all the comments that are going on day in and day out. Is this something that overall helps one particular side? Does it help, the more the defense? Does it help more the prosecution? Or does it help perhaps knowledge of how our system works, or does it muddy it? Because I come from the journalism world, and I find most of my time criticizing my former profession. But I'm wondering for you, and as a criminal defense attorney, if at times it's been helpful. Obviously, your career and the highlight on your work has been very positive, but there has to be other circumstances where they haven't been too helpful.
Oh yeah, I would say 95% or more of the time, a high profile, high publicity case is not good for the defense, because what happens is people are making snap judgments. The media almost always, whether consciously or otherwise, will seek the narrative that is most sensational, that is most likely to draw viewers and interest. That may not be the actual truth, but it may appear that way initially. Sometimes it's generated because of prosecutors having press conferences and publicly stating a particular narrative before the defense has had an ability to do that. But that's generally what people read and hear. And somebody's charged, it's on the front page of the newspaper, or it's on all over the news, before they have heard anything other than the side of law enforcement. And that is often not the case in a close case. The media does have a major role in these cases. Now, it's interesting. America is very different than a lot of countries, including Canada. In America, we have the First Amendment. Freedom of the press is a constitutional right. Other countries do not. They have enacted laws that restrict and limit the media's coverage of certain things. So in Canada or in the UK, a reporter can be held in contempt of court if they are reporting great details and facts about a case prior to the trial. And particularly the closer it gets to the jury trial itself, the greater the chance that's going to happen. And prosecutions are rare, but it's the fact that potential is out there that chills reporters and the media from covering cases in great factual detail. And many people think that's better. In a free society, it probably is better. Frankly, it's better in terms of getting a free, unbiased, fair jury. Mm-hmm. But it also raises the potential for abuse as well, because in a free society, the media is often sort of what keeps politicians and the government officials honest, because they know that if people are watching what they're doing. So it's an interesting tension in America that you don't see elsewhere, and unfortunately, it's not going to change in America unless somebody amends the Constitution, because the freedom of the press is so important in this country. It's got so entrenched that the ability to rein in and limit the media is virtually nil. One exception, by the way, about that is when it comes to cameras in the courtroom. The courts can ban cameras from the court entirely, and historically they often did. In fact, usually did. In federal court, it's still banned. You cannot have cameras in the courtroom. And there's so much misinformation going around. I saw a Facebook post once, or really just last week, I think, that was criticizing the Maxwell trial and saying, mm-hmm. Look at this. We saw everything about Rittenhouse was being live streamed. It's because he was a gun supporter, that they did this, because look at Maxwell was charged with sex offenses and she's not, they don't even allow cameras in the courtroom. Well, that of course is ridiculous. There is a federal rule, and always has been, that cameras cannot be allowed in the courtroom. And there used to be rules like that all over the country in state courts. That has changed in the last 25, 30 years, but still remains the case in federal court.
I've always found it so on a more humorous note, I've always found it so funny when media outlets attempt to report from the courtroom and they have to have the sketches, and some of them are just so bad. And then in my head, I'm like, how does one become a court, I guess, sketch artist?
Yeah.
Yeah, it's like a very niche profession. On the note on the side of the media, and its role, one of the from some of the more measured folks who followed both the Arbery or McMichael and Rittenhouse trial, was kind of the general conclusion that maybe the American justice system isn't quite as rotten as some say it, and inferred that both verdicts were the appropriate ones, and that this is showing that there is still some substance to the core that holds the justice system together. So on the McMichael's case, in the same way for the Rittenhouse case, what is your view on how that case transpired and the ultimate verdict?
You know, the similarity between those cases is that in both instances, the acts which formed the charge were not in dispute, really. The defendants were admitting that they shot. The question is, were they privileged legally in doing so? And in the Rittenhouse case, it was self-defense. And in the McMichael case, there was the additional layer of this citizen arrest, this right to a very unusual, archaic common law right that the state of Georgia had for citizen arrest, which has now been repealed, by the way, after this offense came to light. But it was still an effect and a legal defense in their case. I think there was also a very difference in a big difference, from my opinion, in the quality of the prosecution. I thought the prosecution in the Georgia case was excellent. They did a really good job dealing with the defense that was raised. Not so much in the Wisconsin case at all. So, you know, was it the right verdict in both of those cases? You know, the jury says that it was, and you know, you have to give some credit in the Georgia case to the fact that there were 11 white people on that jury, one black person, involving the shooting by white people of an unarmed black man who they were chasing. And so a lot of people thought that we would not, you know, that he would get off, or that they would get off from the charges, so to speak, because of the race issue, and that did not happen. And so I think we do need to give some credit there to the justice system and being colorblind, you know, given the facts of that trial. Does that mean that the system isn't still broken in my mind? No, it doesn't. I mean,
Of course,
these are two cases out of thousands that happen every day. The vast majority are nobody's watching. And when nobody's watching at all, things happen that should not happen, whether it's corruption or just incompetence or unfair balance. That is the norm in America.
So what do you think moving forward from we have about a minute left. So moving forward from some of these large trials, do you think that increased attention and viewership on some of these high profile cases will aid the criminal justice reform movement?
Well, you know, it's interesting how I think picking individual cases to try and reform or change the criminal justice system is a serious mistake. Mm-hmm. Because what we really need to do is a more measured, thoughtful deliberation about our justice system, where the flaws are, how we can improve them, and those decisions can be done in a democratic way, we would hope, in a bipartisan way, instead of the way we have it now, which is this reaction to individual cases, anecdotes. Much of the laws in state legislatures now, or bills that come at least, come from angry constituents who call their own representative and say, there ought to be a law against this, or this is unfair, this is what happened. And you see it now in Wisconsin with the terrible Waukesha Christmas parade tragedy. where much of the focus, at least at the beginning, was on the fact that this gentleman was released on $1,000 cash bail. How could
Mhm.
that be? We get, obviously the system's broken. We have to change all of our bail and it was a pushback against a cash bail reform effort that has been sweeping the country. But interestingly enough, it has not taken root in Wisconsin. We are not part of that movement. There's been no change in our cash bail system, and yet people, certain people used this incident, this horrible case, to push back against the movement nationwide. It's a human system. Mistakes get made. Some of those mistakes we just can't, we have to learn to live with, and we can try and adjust and make our system better. But to do so based on one high-profile case or a handful of high-profile cases is a mistake, I think.
Yeah, very well said. Well, thank you again, Jerry, for joining us on Consumer Choice Radio. It has been a pleasure, and we will certainly have you back in the near future.
Thank you.